Hi, I'm Pat Murphy, a reporter at Lawyers Weekly, and I'm here speaking with attorney Shannon Liss-Riordan of Lichten and Liss-Riordan in Boston, Massachusetts. Hi, Shannon. How are you today?
Hi, good morning. I'm good. How are you?
Good, good. Shannon is one of the leading employment class action attorneys in the nation. And if there's a class action against a national employer alleging a deprivation of wages, tips, or overtime, it's likely Shannon and her firm are at the spearhead of that fight. Shannon has been making headlines recently, bringing lawsuits across the country over the misclassification of drivers for the ride-sharing companies Uber and Lyft. Uh, in today's Sidebar conference, we'll be discussing the status of that litigation, including a key ruling by a state judge in California and an action taken by Massachusetts Attorney General Maura Healey. Welcome to Sidebar, Shannon.
Thank you. Thank you for having me.
Okay. First of all, before we talk about the Uber and Lyft litigation, how would you describe your practice in your law firm?
We are a national class action firm. We represent workers in all types of mostly wage and hour disputes. We have a specialty in independent contractor misclassification and also tips litigation.
Mm-hmm. How did you decide to focus your practice on employee rights? I mean, where does your passion for employee rights stem from?
Well, this is what I've been doing my whole career, more than 20 years now. From the very first day, I've been an advocate for workers. I just think this came to me when I was in law school. When I was a student, I saw that this was a critical area that people need to have a voice, and large companies have high-powered legal power on their side. But when regular people are being exploited by their employers, they need to be able to fight fire with fire. So this is what I have dedicated my career to.
Mm-hmm. Now, what's your involvement in the class actions against Lyft and Uber? How many have you brought?
I couldn't even count, to be honest. I started suing both Uber and Lyft back in 2013, so it's been a long road. Our firm really got this litigation started with those initial cases, and all of the activity that you've seen since then has really been following in the wake of what we started back then. Back when I first started these cases, I don't think anyone was really thinking about the fact that these newfangled apps would somehow be the leading issue involving employment rights in the country. But they really have caught on in popularity and have become so widespread that I think the ways that they interact with the people who are providing the services is just, it's so crucial now to our figuring out the legal rights of those people, because that's the direction that employment is going now.
Mm-hmm. What states have you filed in? And do you include nationwide class actions against both ride-sharing companies?
So most of our litigation against Uber and Lyft have been focused on Massachusetts and California because we have especially strong laws to combat misclassification and also remedies for workers who've been misclassified. We have done some of the work, some of our misclassification work against the gig economy and other employers in states around the country, but the remedies that you can get and the legal standards just make it much tougher outside these states. So that's a big reason why I'm advocating to enact tougher standards nationwide, even on a federal level, so that we can be bringing more of these cases and trying to get justice for these workers in more parts of the country.
Mm-hmm. Why are these drivers, why should they be treated as employees and not independent contractors?
Well, as you know, there are a lot of legal tests
Right.
that look at different factors, and the big factor that is behind most of the legal tests around the country is the amount of control. And these companies really have a lot of control over these drivers. They try to claim that they don't have control because they can work when they want, they can log on and off when they want. But that's really not the end of the story. When they are working for them, the companies have complete control over their lives. And of course, under our stronger misclassification test that we have here in Massachusetts, the ABC test, it doesn't even matter whether the company exerts a lot of control over the workers. If the work is being performed in the usual course of the company's business, they're their employees. And the reason why they should be recognized as their employees is because these are companies that are building their business models off of this labor. And the workers should be entitled to the same rights that any other workers are entitled to. And the companies are profiting massively if they're able to undercut competitors who classify their workers properly as employees.
Mm-hmm. How have the defendants responded? Are they fighting each of these class actions tooth and nail, or are there any room for settlement negotiations?
These have been tooth and nail battles to the death in many cases. We've had so many appeals and cases that have just gone on for years and years and years. We have reached some settlements along the way and gotten some money back in the pockets of a lot of workers, but the bigger battle to actually bring justice and to these workers and get them reclassified as employees, that is still an ongoing battle.
Mm-hmm. Has arbitration been a hurdle in the recovery in these suits?
Yes, arbitration has been one of the biggest hurdles that we faced because these companies have used these Supreme Court rulings that have come out over the last decade that have blessed companies using arbitration agreements to really get out of systemic enforcement of basic wage laws that protect workers. It's just not really possible to enforce these laws going forward if they have to go through arbitration, because you can never get a ruling that the company is violating the law with respect to everybody. These companies are banking on the fact that if they can enforce their arbitration clauses, they can really minimize their risk and minimize what they have to pay out from these cases, because only the individuals who actually come forward to bring a claim can get any relief. So what we've been doing is we've been waging these multi-pronged battles. We fight in court. We try to get around the arbitration clauses. We've had some wins. We've had a lot of losses on that. And then when we have to go to arbitration, we say, okay, if you want to do these fights one by one, we'll show you one by one. And we file thousands of cases. We've done that against a number of companies where we get contacted by hundreds of workers, and in these gig cases, it's been thousands of workers. And we say, okay, let's go to arbitration.
Mm-hmm. Now, last month, a judge in California issued an important ruling in a state action filed against the ride-sharing companies. Tell us a little bit about that case and that ruling.
Yes, so the Attorney General of California brought its own enforcement action this year against Uber and Lyft, which was a very important development because, of course, state attorney generals don't have to get caught up in the arbitration battles that private lawyers have. So they moved quickly and they got a state court judge in California to issue a preliminary injunction and order Uber and Lyft to reclassify their drivers as employees in California. That decision has now been stayed while the companies appeal it. And there is a ballot initiative that's going to the voters in November where these companies have poured over $100 million into trying to change the law by taking it directly to the voters. So everyone's waiting now to see what happens there.
Mm-hmm. Now, Maura Healey has joined the fray also, right?
Yes, that was an exciting development that in Massachusetts now, our state attorney general has also brought a similar injunction claim. So we are, so this battle is being fought on different fronts.
Mm-hmm. Now, how are those state court actions going to impact the lawsuits that you are bringing on behalf of, directly on behalf of employees?
So the case that Maura Healey's office has brought against Uber and Lyft is looking for forward-seeking relief. They're trying to get the drivers reclassified as employees. We, meanwhile, still have class cases pending, as well as many arbitrations in which we're fighting to get compensation monetary relief for the drivers who've suffered wage violations in the past. And those are still ongoing. And in a very important development, in the case that we have against Lyft, we got a ruling from the federal district court. Judge Talwani agreed with our argument that the Lyft drivers are not subject to the Federal Arbitration Act because they fall under the transportation worker exemption to the act. And Massachusetts law, stripped of federal preemption, would not allow the enforcement of an arbitration agreement with a class action waiver. So that was a very exciting development. Lyft has appealed that, and it is pending now at the First Circuit. Meanwhile, we also have cases that are pending against Uber and Lyft in Massachusetts, or based on Massachusetts drivers, which raises another very important issue that we're trying to get certified to the Massachusetts Supreme Judicial Court, both from the First Circuit and from the Ninth Circuit. And that is this: in California, the California Supreme Court has ruled that companies cannot use arbitration agreements to shield themselves from claims for public injunctive relief, which means that if parties are seeking to force changes in a company's practices, and that change would benefit the public at large and not just the parties to the lawsuit, an arbitration agreement can't stop that from going forward in court. So we have asked the First Circuit and the Ninth Circuit to certify this important issue of Massachusetts law to the Massachusetts Supreme Judicial Court, because I think if faced with that question, they would agree with the California Supreme Court that arbitration was never intended to stop that type of ongoing forward-looking enforcement activity. So we're very excited to see what happens there.
Okay. Hey, thank you so much for your time, Shannon. Any other developments that employment lawyers should be looking forward to on the Uber and Lyft front in the coming months?
Well, there is a case that was actually argued this week at the Supreme Judicial Court involving the enforceability of Uber arbitration clauses, and that's a case involving passengers.
Right.
The court's going to be taking a look at the question of how clear and conspicuous does it need to be that users of an electronic platform are waiving their rights to proceed in court in order for it to be enforceable in Massachusetts. So that's another thing to watch out for.
Yeah, okay. Hey, thank you again, Shannon. Thank you for participating in Sidebar Conference, and good to meet you face to face.
All right. Thank you so much, Pat. Appreciate it.
Take care. Bye-bye.